Good afternoon. I'm Leander van Wyk, Civil Supervisory Legal Practitioner at Legal Aid South Africa George Local Office.
Hi, good afternoon. I'm Lurine Piek. I'm also in the civil section. I'm a civil legal practitioner, also at George Legal Aid SA offices.
So today is the first day of National Wills Week. During this week, you can visit your nearest Legal Aid South Africa office, and we have a basic will drafted for free. This Facebook Live broadcast will be focusing on wills and deceased estates. Any questions you have, you can post in the comments and we'll be answering them for you. I'll now be handing over to my colleague.
Thank you, Leander. So firstly we're going to have a little chat about what is a will and why is it important to have a will, who makes a will, and those type of basic questions. So firstly, what is a will? Now, a will is a document made by a person, usually called the testator, in which he makes sure that his belongings and possessions will be distributed in accordance to his wishes after his death. So, important question is, who can make a will? So, any person of the age 60 years and older can make a will. That is, unless such a person is mentally incapable to appreciate the nature of such a will. It is advisable for any person that does want to make a will to approach an attorney or somebody with knowledge to assist them, because there's very specific requirements that needs to be followed when making a will in order to ensure that that will is a valid will. So basically there's the requirements for making a will is that the will needs to be in writing, it needs to be signed by the testator and two witnesses. So those witnesses needs to be at least 14 years or older. That testator can sign by means of his signature or any mark that he feels is a mark that he feels is representing himself with, and he can also sign with a thumbprint. Let's see.
I think we should remember, when you do sign with an X or a thumbprint, you should make sure that there is a commissioner of oath that is present when you sign that will, and he needs to sign also every page, and to make sure that that will is also valid.
Yes, and then also along with your two witnesses.
Correct.
Then what is very important is that you must remember that the persons that sign as a witness on your will is disqualified from inheriting as a will. So get somebody that is not one of the people that you want to leave something, bequeath something on. So get somebody maybe like a neighbor, or lots of people gets their religious leaders or somebody like that to assist them thereof. Now, if the will consists of more than one page, it's important to remember that each page needs to be signed by the testator and the witnesses that signs with the testator. Any provision of the will may not be against the public interest or good morals. So you must make sure that your will is capable of executing, and that it is in good morals. Then basically the elements that must be included in your will is it must contain a distribution of your property, and it must identify the heirs that you want to leave your properties and assets to. it is important to remember to properly identify the people that you want to leave your assets to. Then it is also important to remember that there's certain implications if the children, if the heirs in your will are children, then you must make sure and remember that they cannot deal with those assets themselves, and usually you make a provision for the nomination of a legal guardian, or for more complicated matters you can make a testamentary trust, or and then lastly, it is important to, with your will, make a clause that any previous will are cancelled with that new will that you are now testating to.
Yeah, I think we can basically summarize, especially for clients that intend to visit our offices during this week. What is important is to bring along your ID, your full names, your ID of your spouse. We should be informed how are you married, whether in or out of community of property, a copy of such a marriage certificate. If you are divorced, please bring along your decree of divorce, and also the full names and IDs of all the beneficiaries or the people you want to benefit from the will. Details of all the assets as well, so that we can draw up a basic will for you in that regard. So I think that's important to remember when you come to visit our office.
Yes, then one of the reasons why it is important to make a will is to understand the implications if you do not make a will. So if a person dies without a will, it means that the word used for that is that it will be intestate succession, yes. That means that the assets will be divided not in accordance with the testator's wishes, but rather in accordance with what is set by law. So then there's a legal way of how the assets will be inherited by the family or the spouse or the family. In terms of intestate succession, property usually goes to spouses and children, and after the spouses and children if the spouse or the children is not available, then it will go to extended family. Then shortly, let's see. We touched on it, but when children inherit in terms of a will, that will usually go to a guardian's fund if there is no trust or other means made for the inheritance of the children, if there's cash amounts.
Yeah, and I think we can then also follow up. Once we have drafted the will, it's important that you should keep the will safe and in a place where it can easily be found by either your relatives or by a person that you trust. The original should be available, because that is what you will need to submit in order to register the estate at the master's office. I do not know whether we're ready to move on to the estate reporting, or do you still have something on the wills?
No, I think we can move on to administration of estates. And obviously how to report a deceased estate, because that is usually the next step after somebody died with a will. It is important that somebody must report the estate within 14 days.
Yes.
The place where you go to report the estate will be at the master's office. There's a master's office in at every magistrate court. There's an assistant master that can assist you with that. So who can report the estate? That is basically any interested party can go and report the estate, and it is very important that there's also a time limit in which that estate needs to be reported. That time limit is 14 days. There is a couple of documents that needs to be taken with when you report the estate. So it is very important, although it is not always a good period, but that the family and the so on that needs to report that estate starts with the necessary as soon as possible. It is very important to also know that when you approach the master's office, there is certain documents that you need to take with. And one of these documents is the death notice. That death notice is a document that you will get from together with your death certificate at the Department of Home Affairs. It is also, if I'm correct now, the death notice is, you also need that letter from the doctor or the hospital where that person passed away to confirm that that person passed away.
Yeah, I think they refer to it as a BI form. It's a notification of death form that you will receive either from the mortuary or then from the doctor himself. And while we're on the estates, I can just inform everyone that Legal Aid also has an agreement with the master that we do assist family members with reporting an estate. Specifically, it's only with regards to Section 18.3 estates. That will be, in easy terms, we can say that's all estates where the monetary value is less than 250,000. And the agreement further states that the beneficiaries of such an estate is minor children. Then you can also approach your nearest local legal aid office and we can assist you with such estates.
So like my colleague just said, there's basically two types of estates that can be reported. He mentioned we are assisting with estates below the value of 250,000 rand. So when an estate exceeds the value of 250,000 rand, then usually one gets what is referred to a letter of executorship, whereas when the estate value is below 250,000, it is referred to, you get appointed as a master's representative. It is a little bit more straightforward when your estate is what is called a Section 18.3 estate, which is less than 250,000 rand. That is a little bit more easier estate to deal with.
Yes, there's less formalities to comply with at the master's office. As an executor is not appointed, you're just a representative of the master.
So the master basically assists you more. Whereas if your estate exceeds the value of 250,000 rand, then letters of executorship are issued, and then to that executor that are issued with that letter have very specific duties which he needs to comply with when administering the estate.
I think we've covered all the basics. I don't know whether we have any questions as yet.
Okay. How do you find out if someone had a will? If they've passed away, you're not sure where their will is. Do they have a will? What does someone do?
Well, it's a bit difficult to answer, but the first thing is the estate needs to report it to the master, and one of the requirements is that you then submit a will. The onus will be on the family members to provide such a will. As indicated earlier by Ms. Piek, if you do not have a will, unfortunately it will then fall under intestate succession, which in lots of cases have dire consequences for the family members. So I think it is better to clear it up with the other family members beforehand. But unfortunately, if it wasn't done by an attorney, obviously if it does what was done by either an attorney or the deceased banker, usually you can get copies from them. As the case would be, the original would be given back to the client and copies will be kept at then either an attorney's office or at the bank. So you can possibly follow up there if you know he has an attorney or he has a banker, but otherwise it will be a bit difficult to establish. And then obviously if it's been reported, the master will have to disclose whether there was a will and whether it was accepted by the master as a valid will.
And if I visit legal aid, say this week, and I have a basic will drafted at no cost, what do I do with it then? Must I just keep it safely at home? Do I need to give it to my bank?
It is very important to keep that will at a safe place where maybe your other documents, your personal documents are being kept. So no, it's not necessary to give it to your bank. You can just keep that document at the safe place. It's always also a good idea to maybe have a copy made of that will that is maybe commissioned, certified as a true copy, and you can give that to some family members so that they at least know that somewhere between your documents your original will be placed, and share with your family where you put your will so that they know where to go and look for should they be in the circumstances that they need to look for something like that.
Yeah, I think that's a very important point. Just to hop on that, I think it's important to discuss it with your family and to make them aware of the will and the contents of the will. So once you are not there, that there might not be any struggles or any disappointment by all the family members. So as my colleague has said, the best thing is keep an original safe, but make copies and distribute it so that everyone already knows what your wishes are before you pass away.
And how long does it take through the master's office? How long does it take to then wind up an estate?
Well, in a perfect world, if I can say it like that, it might take anything from 9 to 12 months. But usually, especially now with circumstances like the pandemic that has slowed things down, unfortunately there is a backlog at the master's office, so it can take very long, especially if there's other things involved like pension funds and other institutions that needs to be part of the administrating of that estate. But it can take anything depending on whether there is immovable property that needs to be transferred, and the amount of assets in the estate. It can take anything from 6 to up to 3 years. But if there's lots of assets involved and maybe testamentary trusts and children and pension funds, unfortunately some of those things can have a delay on the administration.
But in terms of the letters of authority, the estates we work mostly with, I think the master has set a time limit of about 6 months.
Yes.
That you need to try and finalize the estate if
Yes.
possible. So
Yes.
it is possible, but as said, it depends on the individual circumstances of each estate.
So also a larger estate with lots of assets and immovable property will take a longer time, where estates with section 18.3 with values less than 250, those estates take a shorter period of time, because there's also not that many requirements that need to be fulfilled with, like a estate where that exceeds 250,000 rand. That type of estate needs to be advertised, and it's got a specific liquidation and distribution account that needs to be made available for public to see. So if there's longer periods that is required by law to finalize that estate.
Then if there's a situation where someone has passed away, we haven't found a will, we don't know that there was a will, and the family has already started taking elements from that person's home, taking some of the assets, distributing it amongst themselves, what do I do? What can I do to stop this? If I am the child of the person who passed away, I don't think the family should be getting it. I think I should get something. What can I do?
The important thing is, as we said, you need to report the death actually within 14 days, because as soon as an appointment is made, either in terms of the letter of authority or then a letter of executorship, whoever gets appointed by the master then has the authority to claim all those assets and to make sure it's preserved so that it can be distributed to the correct beneficiaries. As we said earlier, if there's not a will, it will be intestate, and my estimate will then be that it will be either the spouse, the surviving spouse, and then the children that will be the beneficiaries of such an estate. So it's important to report the estate as quickly as possible.
Are there any other comments? You guys are happy?
So I think that is, except if there's any other questions from the
Public.
then I think we can conclude the interview and thank the viewers for being with us today.
Yes.
And then it's important to remember that if you require any further legal advice, you can always call our advice office. It's a toll-free number that you can dial. It's 0800 110 110. Their office hours are weekdays from 8 a.m. to 5 p.m. If you cannot call, we also have a please call me number that you can dial. It is 079 835 7179, and then somebody from our offices, our national offices, will call you back and give you the necessary assistance that you need.
We've just had a question come in from Minette at the last minute. What happens if the original will is lost and we only have a copy? Will this then be intestate?
No, not necessarily. If you provide the information together with an affidavit to the master's office, they can still accept that will, and then it will then not proceed intestate, but as per the wishes of the testator.
It is always also important to remember that you can always approach the courts as well for assistance with estate. Even if there was a small requirement that was not adhered to, the court can still assist with invalid wills to see if the courts can give effect to the wills of the testator, because obviously the golden idea is to give effect to the wishes of the testator, so the courts will try to always do that where and if possible.
Right, and then lastly from my side, I again invite everyone to come and join us for National Wills Week, to attend to our office so that we can draft a basic will. If you are not able to visit a local office, please go to our website www.legalaid.co.za. You will also there be able to download a basic will that can be used. Thank you very much.
Thank you very much.